and a very warm welcome to you all to this session of the IGC Summer School. My name is Srinivasan, and I'm from the School of Agriculture, Policy and Development at the University of Reading in the UK. I'm an economist by training, but I found my way into agricultural economics perhaps more by accident, because I really did not have much exposure to agriculture, having grown up in the concrete jungles of New Delhi. I'm very happy to have this opportunity to share my perspectives on an important agricultural policy issue with a group of highly trained economists. This is in fact quite a rare opportunity because, as you may have noticed, most of the time in policy discussions, economists are either absent or they tend to be in a small minority. So today's session is focused on a very specific type of agricultural innovation, that is new varieties of plants or new crop varieties. We will discuss what policy challenges developing countries face in the development and dissemination of plant variety innovations. Now, 20 years ago, in the late 1990s, when I started my research on this topic, there was a lively debate in the country on the pros and cons of applying intellectual property rights in agriculture. There was lobbying by multinational seed companies for enactment of a strong intellectual property rights legislation. At the same time, there were agitations by farmers against the introduction of plant variety rights. There were a range of environmental groups that were up in arms with concerns about how intellectual property regimes would affect the conservation of agricultural biodiversity. And there was a great deal of debate in Parliament on what kind of intellectual property rights legislation India should introduce. 20 years later, you find that these debates are no longer part of the policy discourse. That by itself is an interesting question. Why have these issues somehow fallen off the policy radar? Now, that is a question we will come back to in the later part of this session. But India's response to the policy questions provides quite a fascinating case study of how policy is driven by the need to address competing stakeholder interests. So here is the outline of today's talk. We will first of all start with the question of why we are interested in plant variety innovations. What are the kind of questions that it poses for policy? Then we will look at the policy options for encouraging innovations. We will look at how thinking about the application of intellectual property rights to agriculture has evolved over time. Then we will look at how intellectual property rights in agriculture emerged on the policy agenda of developing countries. Because in the immediate decades after independence, there was no discussion on intellectual property rights. It was in the late 1990s that this issue came up on the policy agenda of India and other developing countries. So we will look at what were the factors which led to the emergence of intellectual property rights in agriculture on the policy agenda. Then we will look at the kind of debate that we had in India on the application of intellectual property rights in agriculture. Then we will look at the policy response and the kind of legislation that was enacted. And finally, we will reflect on what the policy has achieved. What have been its successes? What are the things it has not been so successful in achieving? So this is the broad outline of today's talk. So let us start with the first question. Why are we at all interested in plant variety innovations? And why does it pose questions for policy? So the answer to that question is that new varieties of plants or new crop varieties have made a significant contribution to the growth in agricultural productivity. And through their contribution to the growth in agricultural productivity, they are seen as key drivers of a sustained increase in agricultural production, and that in turn contributes to the self-sufficiency and food security objectives. Now, there are a large number of empirical studies that have highlighted the contribution of high-yielding varieties to the growth in agricultural productivity. And probably new varieties have been the single most important agricultural input in contributing to the growth in productivity. Now, the most spectacular example of the contribution of new varieties to agricultural growth has, of course, been the story of the Green Revolution in India and South Asia. The Green Revolution was actually kick-started by the import of new dwarf high-yielding varieties of wheat from Mexico in the late 1960s, and initially some 18,000 tons of wheat seed of these high-yielding varieties were imported. And the introduction of the Green Revolution varieties paved the way for quite a remarkable agricultural transformation in India, with sustained increase in agricultural productivity and agricultural production. Now, one important point to note is that the Green Revolution varieties were not really developed by the private sector. They were developed in the public sector through a collaboration between the national agricultural research systems and the international agricultural research centers of the CGIAR, which stands for the Consultative Group on International Agricultural Research. So you had institutions like CIMMYT, the International Wheat and Maize Improvement Center in Mexico. You had the International Rice Research Institute in the Philippines in Manila. So these were all essentially international public sector institutions. And the important point to note is that the Green Revolution varieties were actually developed by a collaborative effort between national public sector institutions and international public sector institutions. And there was no discussion on intellectual property rights on plant varieties in those days. Now, another point to note is that innovations in plant varieties cannot simply be a one-off event. We need to have continuous innovation in plant varieties for different crops. And the reason for that is that varieties become susceptible to pests and diseases over time, and they need to be replaced by newer varieties. So the innovation process has to be a continuous one. So there is also potential for further improvements in yield and other agronomic characteristics, characteristics like drought tolerance or disease resistance. And today, of course, you have the issues that relate to the adaptation of varieties to climate change. So innovation in plant varieties needs to be a continuous and ongoing process. Now let us look at the nature of the innovation process. Yeah, so if you, the traditional innovation process has generally involved selection by farmers over generations. Now, plant variety innovations have been occurring for thousands of years. Mutations occur spontaneously in nature, and advantageous mutations get selected by farmers as they cultivate their crops. And this process of selection by farmers over generations is what has led to the traditional process of plant variety innovations. But about 150 years ago, we had the emergence of scientific plant breeding with the discoveries of Mendel. Now, scientific plant breeding involves the planned incorporation of desirable traits in plant varieties using certain techniques and information that is available to plant breeders. So you are not really relying on spontaneous mutations occurring in nature. You are instead using specific techniques to incorporate desirable traits in plant varieties. This could be higher yield, this could be disease resistance, this could be drought tolerance. So the emergence of scientific plant breeding meant that the institutional context of plant breeding shifted. So it shifted from the farmers' fields to an organized activity carried out in plant breeding institutions or in research institutions. So when it comes to plant breeding innovations, the important point is that over a period of the last 150 years, the process of innovation has changed. It has changed from a process which involved selection by farmers to a process where traits are incorporated in varieties in a planned way in an institutional context. Now, it is this shift of plant breeding as an organized activity that really raises the policy questions. So if plant breeding is an organized scientific activity taking place in an institutional context, then what are the incentives for research and innovation? So the questions are, how can incentives be provided for innovation? Now, plant breeding as an organized activity requires investment. So how can investments in R&D be encouraged? How can you accelerate the process of innovation? And importantly, who should be responsible for the innovation process? Should it be left to the private sector, or should it be undertaken by the public sector? And if the innovation is to be left to the private sector, then the question which arises is, will the market mechanism produce an optimal level of investment in plant breeding? So will the market mechanism, if you rely on the private sector for plant breeding, will you have adequate flow of innovations? Now, in the context of industrial innovations, there has been a long history of applying intellectual property rights for encouraging innovations. Now, patents, which are the oldest form of intellectual property rights, were first granted more than 500 years ago in Italian city-states like Venice. Now, these patents were granted to master craftsmen or guilds so that these craftsmen would not take their skills to rival city-states. So it was to keep the skills of the master craftsmen within the city-states so that these city-states could then export their products and gain the economic benefits. So in the context of industrial innovations, there has been a fairly long history of applying IPRs for encouraging innovations. So when it comes to plant breeding as an organized scientific activity, there is a similar question which arises. Can you apply any form of intellectual property rights to plant variety innovations to encourage innovations? So these are essentially the policy questions that we face in the context of plant varieties and plant variety innovations. We will see how these questions have been answered differently at different periods of time. Now, let us have a brief recap of the economic rationale for intellectual property rights. What is the purpose or the economic purpose or rationale for intellectual property rights? Now, as we know, all innovation, whether it's a new gadget that is being invented or whether it's a new plant variety being bred by a plant breeder, all innovation involves the creation of new knowledge or innovation. Now, this new knowledge has certain public good characteristics. Now, what do we mean by public good characteristics? It means that this information is non-rival in consumption. That is, it can be possessed and enjoyed by as many people as care to make use of it. It is durable. It can be used again and again without exhausting it. So there is no need to repeat the same discovery. Another important feature of a public good is that the original costs of producing that new knowledge may be quite high, but the marginal costs of reproduction are quite low. So if you think of a plant variety that is bred by a plant breeder, this plant breeder may have to invest a lot of money in experimenting to produce this new variety. But once this variety has been produced, it can be easily multiplied. It can be easily multiplied by any farmer. So the marginal costs of reproduction tend to be very low. The original costs of producing that new knowledge can be quite high. So in this kind of a process, the incentive that the innovator has for producing innovations really depends on what proportion of the social benefit the innovator can appropriate. So if you have a new variety and the information about this innovation and the seeds of this new variety are freely available to all, then lots of farmers will be able to use the innovation and produce higher yields. So there is a social benefit. Now, for the innovator, the incentive depends on what proportion of the social benefit the innovator can appropriate. So if the innovator can appropriate only a small proportion of the social benefit, then the incentive for the innovation will be low. This in turn means that you will have suboptimal levels of innovation. So in other words, the market mechanism will not really deliver the optimal levels of innovation or investment in the production of innovation. So what can be the policy responses? So if the private sector or the market mechanism cannot be relied on to produce a steady stream of innovations or an adequate stream of innovations, what are the possible policy responses? You can have governmental production. So the state or the public sector can invest in plant breeding, or you can have subsidies. So, or you can have intellectual property rights. So let us look at what intellectual property rights are supposed to do. Now, intellectual property rights provide incentives for innovation by improving the appropriability of returns from innovation. That is, it helps the innovator to appropriate a larger proportion of the social benefit that accrues from the innovation. How is this done? This is done by providing a monopoly right over the use of the innovation to the inventor, or in the case of plant varieties, to the plant breeder, for a certain period of time. Now, as students of economics, we know that if you provide a monopoly to any firm, the price charged for the product will be much higher than it will be under perfectly competitive conditions. And if the price of a product is higher, then lesser number of people will use that innovation. So there is going to be a loss of social welfare. So if you have a new plant variety and a breeder has got monopoly rights over that variety, then the breeder will be able to charge a high price for that variety. And that will mean that not an adequate number of farmers will be able to make use of that variety. And therefore, you have a loss of social welfare. And this social welfare loss is what is referred to as the deadweight loss of monopoly. So intellectual property rights need to strike a balance between providing incentives for innovation and the deadweight loss of monopoly, the loss of social welfare, which accrues because of the monopoly right that is provided to the innovator. So how do they strike this balance? How do intellectual property rights laws strike this balance? The loss of social welfare is generally sought to be offset by restricting the duration for which intellectual property rights are provided. So you specify that the innovator will have patent rights only for, say, a period of 15 years or 20 years. Then you also have the definition of what is called the breadth or the scope of patents. Now, the breadth or scope of patents relates to the kind of claims which you can make based on patents. So if you can make very broad claims based on your patent, then the scope is broad. If you can make only a limited amount of claims against your patent, then it is narrow. So to reduce the social welfare loss due to the grant of the monopoly right, intellectual property rights legislation generally tries to narrow the breadth of patents. Then there are a couple of other points to look at. One is we need to understand the cumulative nature of innovations. So a new plant variety is derived from existing plant varieties. A new invention may build upon previous inventions. So if the monopoly right that is given to an inventor or an innovator restricts the use of the invention completely, then the future process of innovation will get affected. So in most intellectual property right laws, you have what is called the experimental use exemptions. That is, while the innovator has got monopoly rights over the innovation, experimental use of that innovation for development of further development of new innovations, that is always allowed. And this is called the experimental use exemptions. And another point to note is that intellectual property rights are private rights. So if I have a patent and somebody else infringes on that on that patent, then I have to enforce my right through the judiciary or through judicial mechanisms. So the enforcement mechanisms are important in the case of intellectual property rights. So how effective the intellectual property rights are also depends on how effective the enforcement mechanisms are. Now, as we noted earlier, for industrial products, patents have a fairly long history of, say, more than 500 years. But when the policy questions were posed about whether intellectual property rights can be applied to, say, plant variety innovations, that was considered to be quite problematic. Why was it considered to be problematic? The first reason was that the prevailing paradigm about intellectual property rights was that products of nature cannot be subject to intellectual property rights. So plant varieties are products of nature. So you cannot subject something which occurs in nature to intellectual property rights. So even in the context of patent laws, a point that you should note is that you cannot patent discoveries. You can only patent inventions. That means anything which is subject to intellectual property rights should have an element of the inventor's effort to bring about that invention. So you cannot go to, say, the tropical rainforests in the Amazon, find a new variety, and then subject it to intellectual property rights, because that would simply be a discovery. Now, then the other issue was that the traditional patent law concepts, which involve identifiability, novelty, utility, disclosure, or reproducibility, it was considered that these are difficult to apply to plant varieties. So what does identifiability mean? Identifiability requires that an innovation must be capable of precise description so that it can be distinguished from what already exists. Similarly, novelty means that an innovation must be new. It must be what is called non-obvious and must represent an inventive step. Utility means that the use of the innovation must be identified. So, for example, it should lend itself to commercial application. Disclosure means that the description of the innovation should enable a person skilled in the art to reproduce it. So, in fact, in most patent laws, disclosure is a requirement. That means in exchange for this grant of this monopoly right, the inventor agrees to disclose the details of his or her invention to the and put it in the public domain, then it can be used for further innovations. So identifiability, novelty, utility, and disclosure were considered to be problematic for the purpose of application to plant varieties. And the reason was, say, for example, in the case of a plant variety, how do you identify a plant variety as being distinct from another plant variety that already exists? How do you establish utility? So, for example, if a plant breeder breeds a rose variety, say a purple colored rose variety, how do you establish the usefulness or the utility of that innovation? Similarly, how can you meet the disclosure requirement? So normally for plant varieties, you can reproduce the innovation if you have the authentic seeds of that variety. So because of these issues, it was considered that applying intellectual property rights to plant varieties is rather problematic. The other issue was that all plant varieties are derived from pre-existing plant varieties. So the cumulative nature of innovations that we discussed a little while ago, that applies to plant varieties as well. So if you have the cumulative nature of innovations in plant varieties, and then if you give a monopoly right to an innovator over a new plant variety, you might end up stifling further innovations. So nobody else will be able to use that variety for further development, and that may stifle the development of new varieties. So this was also considered to be a problem in the application of intellectual property rights to plant varieties. But the most important difficulty in appropriating benefits from an innovation for an innovator was the problem in segregating and appropriating benefits. That is because seeds are a self-reproducing resource. Now, once the breeder releases the new variety, any farmer can multiply it. The breeder has no further control over the multiplication of that variety, and therefore the breeder will not be able to get any proportion of the benefits that the farmer has got from that, gets from that variety. So seeds being a self-reproducing resource, it is difficult to appropriate benefits for an innovator from a new invention which is self-reproducing in nature. So again, if the benefits from innovation cannot be appropriated by the breeder, then again, as we noted earlier, the market mechanism will not produce an optimal level of innovation. So because of all these reasons, the paradigm about products of nature not being patentable, the difficulties in applying patent law concepts to plant varieties, the cumulative nature of innovations, and the difficulties in appropriating benefits from a self-reproducing resource, it was felt that plant variety innovations cannot really be subjected to intellectual property rights. So if plant variety innovations cannot be subject to intellectual property rights, then what should be the policy response? The conventional policy response to market failure in plant breeding innovations in both developed and developing countries was to resort to public investment in plant breeding. And this was a feature not only of developing countries, but also in developed countries as well. So this is the public investment in plant breeding was the concept which underpinned the emergence of the land grant universities in the US. These were all state-funded universities which were given large grants of land so that they could invest in agricultural innovations. Similarly, large national agricultural research systems in the public sector emerged in developing countries as well. So if you look at countries like India, you look at countries like China or Brazil, all of them invested in large public sector institutions that were mandated to take up agricultural research. Because with public investment in plant breeding, you don't really have to be worried about the incentive question. Public sector institutions can be simply be mandated to undertake certain types of research. So you can tell the public sector institution that you want to develop varieties that will be suitable for small farmers or for marginal areas, or you can ask them to develop varieties for a particular crop. So public investment in plant breeding was the initial response, and this was supplemented by the collaboration between the national agricultural research systems in the public sector and the international agricultural research centers, which, as we noted earlier, made a substantial contribution to the development of the Green Revolution varieties. And we have already noted the spectacular contribution of public research systems to new variety development. And we have already noted the example of the Green Revolution of the 1960s and 70s. That was completely led by public sector innovations. So if market failure was being addressed by large government investment in R&D in both developed and developing countries, and if public sector research was producing great innovations, for example, it led the Green Revolution, then could we simply not have lived happily ever after? Why was there any need for change? So, because we could have continued happily investing in the public sector and the public sector producing innovations. So there was really no need for, you could argue that there was no need for any change in perspectives or in change in policies. Now, the change, or rather the factors contributing to change, there were a number of them which emerged. The first one, and these factors led to a much larger role for the private sector in plant breeding. So the first factor which led to the private sector being seen as having a larger role in plant breeding was the declining trends in investment in public sector agricultural R&D in both developed and developing countries. So if you look at the trends in public sector R&D investment over the period 1970s to 2000, you will find that there is a fairly significant decline in public sector investment in agricultural R&D. This was mainly because of fiscal constraints in both developed and developing countries. The second factor which provided the private sector a larger role in plant breeding was the success of the private sector in the development of hybrid varieties. And the most striking example of that is the development of hybrid varieties by the private sector in the US maize industry. Now, one thing to note about hybrid varieties is that hybrid varieties, in some sense, have inbuilt intellectual property rights protection. Now, hybrid varieties are developed by crossing varieties. So you cross variety A with variety B to produce variety C. And this variety C has got what is called hybrid vigor. Now, one feature of hybrid varieties is that farmers need to buy fresh seed every year. Farmers cannot use farm-saved seed as they suffer from substantial decline in yields if you use farm-saved seeds of hybrid varieties. So if you developed hybrid seeds, then what that also means is that the farmer will have to buy seeds from the seed company year after year. So which is the reason why the private sector development in the US and in other Western countries focused on the development of hybrid varieties. And these hybrid varieties, for example, in the maize industry, were extremely successful. They provided very large increases in yield. And over time, they completely displaced the so-called open pollinated varieties, which the public sector had been developing. The third reason was that in the 80s and 90s, when biotechnology-based innovations came up in plant breeding, for example, genetically modified crops, you talk about BT cotton or BT maize. So these are genetically modified varieties of crops based on biotechnology innovations. Then it was the private sector which had a dominant role there. So when it came to biotechnology-based innovations, it was the private sector which was dominant. Biotechnology-based innovations required huge investments, and which only very large private sector companies could make. And another feature was that in the case of biotechnology-based innovations, the private sector was able to subject these innovations to patents rather than to plant variety protection. And so that means the appropriability of returns was much greater. So these three factors really led to a larger role for the private sector in plant breeding. And that in turn led to sort of re-energize these questions about what kind of intellectual property rights regime we need for plant varieties. At the same time, there was some kind of a paradigm shift, and there was some creative adaptation of IPR concepts, patent law concepts, to novel plant varieties. So what was this paradigm shift all about? Now, we started off with the proposition that products of nature, or something which simply occurs in nature, cannot be patented. So, for example, you cannot patent a gene. A gene is something which occurs naturally in nature. So you cannot patent a gene. But there has been a gradual shift of the paradigm when it comes to this concept that products of nature cannot be patented. So while a gene cannot be patented, genomic information, which is used in the manipulation of genes, can be patented. So over time, you will find a gradual paradigm shift which blurs this distinction between what occurs in nature and what has been developed by as a result of human effort. So, and this has been most pronounced in the biotechnology area. Similarly, you have had creative adaptations of IPR concepts. So what are these creative adaptations of patent law concepts which allow the application of intellectual property rights to plant varieties? Let us look at identification, which we said is a requirement or a criteria under patents. So for plant varieties, the development of systematic botany or morphology, so that where you identify a plant or a plant variety by its characteristics, that allowed the identification of new plant varieties. Now, novelty is difficult to establish for plant varieties. So instead of novelty in the sense that the plant variety had not existed previously, the concept of commercial novelty was actually introduced. So commercial novelty meant that the plant variety had not been commercially sold for more than a certain duration of time. So, yeah, in terms of creative adaptations, how do you establish the utility of a plant variety? I gave you the example of a purple colored rose. How can you show that a purple colored rose has got any utility? So in the context of plant variety protection, the requirement of utility was actually dispensed with. You only have to show that a variety is novel and it is new. You don't really have to show that it is useful. Now, in terms of the disclosure, how can you deal with the requirement for disclosure? Now, the requirement for disclosure in the case of plant varieties was met by requiring the deposit of a sample of the reproductive material, that is seeds. So if you deposit the seeds of a new variety, then it can be reproduced, and that meets the disclosure requirements. So two important elements. One is that the private sector gradually began to have a larger role in plant breeding. Then there were certain paradigm shifts and creative adaptations of patent law concepts to make them applicable to plant varieties. And as a result of that, European countries, mostly Western European countries, introduced a form of intellectual property rights which is called plant variety protection. And they introduced legislation for that in the 1960s and 70s. The US, in fact, had plant variety protection even from the 1920s, but that was only for what they called vegetatively propagated varieties. The argument was that vegetatively propagated varieties will always reproduce true to type. If you're reproducing a plant from seeds, it may not reproduce true to type, but vegetatively propagated varieties will always reproduce true to type. And therefore, right from the early 1930s, the US had a legislation for providing intellectual property rights protection to vegetatively propagated varieties, which meant that it was mainly applied to horticultural crops, say apples or other fruit crops. So that is how the emergence of plant variety protection happened in the legislation of European countries, and that is something that dates back to the 1960s and the 1970s. But of course, none of the developing countries really considered that. in developing countries, the prevailing paradigm was that it has essentially to be the public sector which undertakes research in plant breeding. So we had the Indian Council of Agricultural Research, had a huge network of plant breeding institution and crop improvement institutions. And even today, the public sector in India has a very, very significant and dominant role in plant breeding. So before we look at the issue of what happened in India, one point to note is that in addition to the paradigm shifts and the emergence of a large role for the private sector, intellectual property rights, including intellectual property rights on plant varieties, were included in the GATT negotiations as an issue for negotiations in GATT. And it is these GATT negotiations in the late 80s and early 90s that led to the formation of the WTO and what is called the TRIPS agreement, which is the agreement on trade-related aspects of intellectual property rights. So the inclusion of intellectual property rights in the negotiations leading to the formation of the World Trade Organization and the TRIPS agreement was a part of that. That in many ways was a kind of a game changer. So let us see how that really made a difference. But before we go to that, we need to take a look at the harmonization of intellectual property laws across countries. And this is quite an important factor which affects the implementation of IPR laws. So let us look at the issues surrounding the harmonization or the need for harmonization of intellectual property rights laws across countries. Now, IPR laws only have a national jurisdiction. Now, this raises issues for protection of innovation across jurisdictions. So if I come up with a new invention and I get a patent for it in India, that doesn't give me any protection in the United States. If I want a protection for the same invention in the United States, I need to make a separate application in the United States. And if I want a protection for that invention, because it's going to be sold, say, in the UK, then I have to apply under the UK patent law. So IPR laws have only national jurisdiction. And this can pose problems for inventors when they try to protect their inventions across jurisdictions. So therefore, there is a need for harmonization of intellectual property rights legislation across countries. And this has been sought to be done by having what are called international property rights conventions to which different countries sign up. So for example, you have the International Patents Convention. So all countries which have got patent laws, they can sign up to this International Convention on Patents. And this is in fact quite an old convention, I think dates to 1860 or something like that, the International Patent Convention. So what are the key components of international IPR conventions? Now, the first thing is that they provide common standards or criteria for protection in terms of the scope, the breadth, or the duration of IPRs. So, for example, if you're part of the International Patents Convention, then your patent law will have uniform duration for protection, because it will be problematic for the inventor if, say, a patent is valid only for 5 years in one country and 10 years in another country. Similarly, it will also be problematic if the criteria for patenting is different in different countries. So international patent conventions or international IPR conventions try to provide common standards or criteria for protection. They also provide for reciprocity, or what is called national treatment. That means if you recognize or extend protection to the applications made by our nationals, we will extend protection to your nationals. So that means your inventors will be able to apply for patents in our country. Our inventors should be able to apply for patents in your country. Now, national treatment, in fact, is an important ingredient of the TRIPS agreement. Then what you have is a very important feature of international patent or IPR conventions is what is called the right to priority. So if you have an inventor who makes a new invention and, say, gets it protected in the home country, let's say an inventor gets a patent protected in India. Now, it can so happen that the same patent can be applied for, somebody else, say, copies that invention, and they can apply for a patent in, say, the US. And they may get, in the US, they may get a patent before, say, this inventor from India has had a chance to apply for a patent there. To avoid this kind of a situation, international patent conventions have what is called the right to priority. So if you have applied for a patent in, say, India, for applying for a patent in any other country, you will have a priority for a period of up to 1 year. Now, right to priority can generally be based on what is called the first to invent. That is whoever is the first to invent an invention has the right of priority for applying for a patent in all the jurisdictions which are signatory to the International Patents Convention. The US follows a slightly different system where it is called the first to file. So that is a slightly different system. But international IPR conventions emphasize on common standards or criteria for protection. Then they go in for reciprocity provisions and the right to priority. So International Patents Convention is perhaps the oldest of the lot. There are similarly conventions for other IPR laws as well, such as for copyrights and trademarks. So what I want to move on to next is to look at, firstly, what does the International Convention for Plant Variety Rights look like? So we will take a look at the features of what is called the UPOV Convention. And then we will move on to a discussion of how the legislation came about in India, what were the features of this legislation, and then we will move on to a consideration of what that legislation has achieved. Okay, so let us look at the UPOV convention, so as we noted, a number of European countries and also the US introduced their plant variety protection legislation in the 1960s and 70s. And there was a need for harmonization of plant variety protection legislation. And this harmonization was provided by the UPOV Convention. This is the French acronym for the International Convention for New Varieties of Plants. Now, the idea was that the UPOV Convention should provide common standards of protection. So the common standard of protection, which was introduced by the UPOV Convention, was that plant variety protection would be based on what is called the DUS criteria. That is distinctness, uniformity, and stability. So these are different from the criteria that you have for patents on industrial products. So distinctness means that a variety should be different from all currently existing varieties. Uniformity means that all plants of that variety should have similar characteristics. So if you have a population of plants of that new variety, all plants should have similar morphological characteristics. Stability means the characteristics of a variety should be stable as they are reproduced from generation to generation. So the UPOV Convention introduced the criteria for plant variety protection, and these were termed as the DUS criteria: distinctness, uniformity, and stability. Now, one of the issues which even the European countries had to address was the right of farmers to use farm-saved seeds for replanting their own land or for doing whatever they wanted with the farm-saved seed. So farmers have been exercising this tradition of using farm-saved seeds for planting the next round of crop for millennia. So it is a practice or a tradition which has gone on for centuries. And it would be very difficult for the breeder to say that my right over this variety, and remember the breeder's right extends to the reproductive material of that variety, that is to the seeds of that variety. So it would be very difficult for the breeder to argue that for a new variety which is protected by plant variety protection, the farmer will not be able to use farm-saved seeds, or if the farmer uses farm-saved seed, he will have to pay a royalty or some kind of a premium to the breeder. So, and this would evoke huge resistance or opposition from farmers. So the UPOV Convention, the initial convention of 1978, recognized what they call farmers' privilege. It's important, the wording is important. It is not called farmers' rights. It is called farmers' privilege. So the UPOV Convention said that the breeder will have no rights over the farm-saved seed of the new variety. This means that the farmer, even if the farmer has adopted the new variety, has bought the seeds at, say, a high price, but once the farmer has brought the variety and has used it to cultivate the crops, the farm-saved seeds can be used by the farmer for planting the subsequent round of crops, or even for informal exchange or whatever. So the farmer's privilege was recognized in the UPOV 78 convention. And the other element which is also recognized in the UPOV convention, which is particularly important for plant variety innovations, is what is called breeder's exemption. Now, which means that although a variety is, say, protected by plant variety protection, it can still be used by other breeders for developing further innovations. Because if this breeder's exemption is not there, then the whole process of innovation will grind to a halt. If you say, if the breeder is allowed to say that nobody will use my variety for further development of newer innovations, then the whole process of innovation will stop. So breeder's exemption is like the research exemption that you have in patents. It allows protected varieties to be used in research for the development of new varieties. And the UPOV convention also includes the concept of reciprocity and national treatment. It also has the right to priority. So if a breeder develops a plant variety in one country and applies for plant variety protection in that country, then the same breeder will have the right of priority to apply for protection in all other countries which are signatories to the UPOV convention. And then you have certain administrative arrangements between members which are signatories to the UPOV convention. So for example, this could relate to the mutual acceptance of testing results. You have the DUS guidelines for different crops. These are standardized. So it has got a lot of administrative convenience aspects built into it. So, a variety may not have to be tested in each jurisdiction if there is a provision for mutual acceptance of testing results between different countries. But that's mainly on administrative arrangements. Now, the UPOV convention was actually revised in 1991. And the main drivers for the revision of the UPOV convention were essentially the breeder interests. Now, the breeders argued that once they release the new variety, they release the first batch of seeds of a new variety to farmers. After that, they get virtually no revenues from the sale of that variety, because the farmers are able to use farm-saved seeds. So the appropriation of benefits from their innovation is seriously constrained by the fact that farmers are able to use farm-saved seeds. And therefore, it was argued that UPOV 1978 actually provides a very weak form of protection, and there is a need for strengthening that form of protection. So what were the changes which came about in 1991, which was mainly at the instance of the private sector seed company interests, and essentially the plant breeding private sector interests. So UPOV 1991 brought about a change which said that farmers' right for the use of farm-saved seed can be provided, but only as an exception to the breeder's rights. So, which said, what it meant was that countries can provide farmers the right to use farm-saved seed, but only as an exception to the breeder's rights, Further, countries could choose not to provide this exemption to breeders' rights. So in many countries which signed up to the UPOV 1991 convention, over a period of time, the farmer's right to use farm-saved seed has been, this is for protected varieties, has been taken away. So for example, here in the UK, which is signatory to the 1991 UPOV convention, farmers can use farm-saved seeds of protected varieties, but if they use farm-saved seeds of a protected variety, they still need to pay a royalty to the breeder. Now, of course, this royalty will be somewhat less than the cost of buying fresh seeds, but there is still a royalty that has got to be paid to the breeder. The other important change which came about in the UPOV 1991 convention is this introduction of what is called essentially derived varieties. Now, let us say, a branch breeder develops a new variety of soybean. Let us say it gives you much higher yields. Now, under the UPOV 1978 convention, which was based on this distinctness, uniformity, and stability criteria, it would be possible for another breeder to give it a minor tweak. There is an example given, for example, of a soybean variety which was developed and protected. Another breeder got hold of that variety and tweaked it slightly. The flower was of a different color. And that variety, because it was distinct from this variety, was then protected separately. So this meant that breeders would effectively lose their protection because, if somebody else could make a minor tweak to that variety and get it protected elsewhere, then the breeder would really lose, their revenue streams from that variety. So this concept of essentially derived varieties was introduced. Now, what this said was that a breeder's right shall extend not only to the original variety that the breeder protects, but also to varieties which are essentially derived from this variety. That is, if two varieties have essentially the same genetic composition, but they have minor characteristics, differences in characteristics, like, for example, the soybean plant with a slightly different flower color, then the original breeder's rights will still extend to this essentially derived variety. But in one way, this was actually a very major shift in plant variety legislation, because it is shifting from morphology or physically identifiable characteristics to genetic composition. And that, of course, has created a lot of problems in the implementation of the legislation in many countries. But the concept of essentially derived varieties was introduced so that breeders don't lose effective protection just because somebody else gets hold of the protected variety and makes some minor tweaks to that variety. So the concept of essentially derived varieties was brought in. And then it also provided that, breeders can take enforcement action against products rather than the seed's reproductive material in certain circumstances. So as we noted, the breeder's right extends only to the seeds of the variety. It does not extend to the products of that variety. So if a wheat variety is protected, the breeder's right extends to the seeds of that variety. It does not extend to the wheat which is produced with the help of that variety, or the flour which is produced with the help of that variety. Yeah, so that the last point was about this enforcement action against products rather than seeds. Now, say for example, say a Dutch plant breeder develops a new rose variety, now which is protected, say, in the Netherlands. Now, suppose somebody takes that variety to, say, a country which does not have plant variety protection. I'm just taking the example of Kenya. So although Kenya does have plant variety protection, suppose somebody takes it to Kenya and sets up a huge floriculture unit using that variety. Now, the breeder doesn't really have any way of enforcing his or her rights against the floriculture unit in Kenya, because there is no plant variety protection in Kenya, let's assume. But then if that unit tries to export the flowers to the, say, back to the Netherlands, then originally the breeder would have no rights against those exports, because the breeder's rights extend only to the reproductive material. It will not extend to the flowers which are reproduced using that reproductive material. So what UPOV 1991 said was that if the breeder has not had a chance to enforce rights against the infringer, when it came to the reproductive material, then when the product is exported back into the country, the breeder will be able to take enforcement action. So the breeder will be able to get, say, an injunction saying that this product has been produced by using my protected variety without paying me any kind of royalty or license fee, and therefore the exports should be stopped. So the UPOV 1991 convention was mainly about strengthening breeders' rights, and all these elements that I have discussed were essentially meant to improve the appropriability of returns. Basically, breeders should get more money from their innovations. That is what we mean by the appropriability of returns. So all this was essentially a matter for debate. And as Mr. Pal pointed out previously, in India, by and large, there was really no debate about the introduction of intellectual property rights in agriculture or to plant varieties. The public sector had a dominant role in plant breeding. It had a mandate to produce new varieties. It had a mandate to distribute and disseminate those varieties. And the experience of the Green Revolution showed that the public sector did a very good job. And so therefore, there was no real driver for introducing intellectual property rights to encourage private sector innovation in India. What made the big difference in India was, and that is why I have called it the tipping point, was the agreement on trade-related aspects of intellectual property rights, or the TRIPS agreement. And what I have put up on this slide is the famous Article 27.3 of the TRIPS agreement, which says that members may also exclude from patentability diagnostic, therapeutic, and surgical methods for the treatment of humans or animals, plants and other animals other than microorganisms, and essentially biological processes for the production of plants or animals other than non-biological and microbiological processes. So basically this says is, what it says is that member countries of the WTO need not protect plants by way of patents. But the important part is the highlighted portion, which says that members shall provide for the protection of plant varieties either by patents or by an effective sui generis system or by any combination thereof. The provisions of this subparagraph shall be reviewed 4 years after the date of entry into the force of the WTO agreement. So the major provision here was that members shall provide for the protection of plant varieties either by patents or by an effective sui generis system or by any combination thereof. So what this said was that developed countries or developing countries, everyone has to provide for plant variety protection by means of their legislation, but it did not really say what kind of legislation they should have. They could develop their own legislation which was suited to their own purposes. So, and the TRIPS agreement does not mention the UPOV convention at all. But the general understanding at that time was that a legislation which is in conformity with the UPOV convention would be considered to be effective. So it doesn't really specify what an effective legislation is, but that was the general understanding at the time, that a legislation which conforms with the UPOV convention will consider to be an effective legislation. And there were time limits for countries. So developing countries had 5 years in which to implement a plant variety protection legislation, and non-compliance you could have a series of potential sanctions or trade retaliatory measures which could be imposed on you if you did not comply. So the TRIPS agreement was really the tipping point or the game changer, because previously, while we could have had endless policy debates on whether we need intellectual property rights or not, at least in India, there was no real demand for bringing about an intellectual property rights legislation. We could have continued to argue that public sector research in agricultural R&D was all that we really needed. But this made it, this in fact, in a sense, gave us no choice really. So we had to, because if we wanted to, because we had signed up to the WTO agreement and the TRIPS agreement, it was therefore mandated that we had to introduce a plant variety protection legislation. So that was really what really made the difference, and why something which had been simply been a matter of policy debate, it became a kind of a compulsion or a necessity. Now, before we look at the debate in India, let us see what was the case made for the introduction of intellectual property rights legislation in developing countries by the developed countries. Because the inclusion of IPRs in the GATT round of negotiations was actually taken up by the at the instance of the developed countries. And the main argument of the developed countries, they wanted that intellectual property rights legislation should be universalized. That means should be there in all countries. Their main argument was that their companies, which were investing a lot in producing innovations, were suffering huge loss of revenue because of the absence of intellectual property rights in developing countries. So there used to be a lot of assessments of how many, millions of dollars US companies have lost because of the absence of intellectual property rights in other countries like India, China, Brazil, and other countries. So And of course, we are all aware of this issue of intellectual property rights, piracy. So you may remember that previously copies of, say, Microsoft Office, you could get it for a few hundreds of rupees in the Nehru Place market or in the Janpat market. Although Microsoft may have spent millions of dollars in developing the the software, that software was easily reproducible. Marginal costs of reproduction were very low, so it could be easily reproduced, and that of course meant that Microsoft would not gain, would lose revenue. So the loss of revenue argument was the main argument, and that could be extended to plant varieties, it could be extended to industrial products, it could be extended to semiconductor chips or whatever. But in addition to that, the developed countries also made an argument that IPRs would actually be beneficial to developing countries. And what they argued was that intellectual property rights would provide a stimulus to innovation in developing countries as well, by providing better incentives for increased investment in R&D. So the argument was that the domestic seed industry investment in plant breeding would improve if there were intellectual property rights. There would be better flow of FDI or foreign direct investment in the seed sector. That would be also be a benefit. Similarly, it was argued that intellectual property rights would enable technology transfer. So the argument was that if new varieties developed in a foreign country, but then it will not be made available to India unless India also offers intellectual property rights protection. So having IPR legislation would facilitate technology transfer as well. And then, of course, technology transfer would also mean that intellectual property rights would allow the innovation to be used for further innovation, because in the absence of intellectual property rights, companies would regard to measures such as trade secrets, which would not really allow the use of the innovation for further rounds of innovation. Then, of course, it was argued that it would also benefit international trade. So I gave you the example of the export of roses from Kenya to the Netherlands, which could be blocked by the breeder if there was an infringement of intellectual property rights. But if Kenya also has an intellectual property rights legislation, then this will promote international trade, because it will be possible for Kenya to export flowers to the Netherlands. So these were the arguments that were made by the developed countries, saying why intellectual property rights should be introduced in developed countries. And of course, if you look at the TRIPS agreement, this is the kind of view that actually prevailed. But in India, there were a number of different concerns. And let us look at these concerns. First of all, the concern was that the PVP legislation is not really something that was needed by India. It was seen as a kind of an external imposition. So there was a need to reassure stakeholders that the government was not simply, succumbing to pressures from developed countries. The other major concern was that plant variety protection could be exploitative of farmers. That means if plant variety protection leads to restrictions on farm-saved seeds and higher prices of varieties protected by IPRs, then the number of farmers who could use those varieties would be limited, and most probably the poorer farmers would be excluded. And therefore, this would again adversely affect farmers. And it was argued that farm saving use of farm-saved seed is a tradition extending, across centuries, and this is not something that the legislation could seek to restrict. Then it was also argued that if you offer intellectual property rights protection, you would witness a large influx of foreign varieties, and this would lead to dependence on foreign varieties. So over time, you would become dependent on foreign varieties. And this was happening at the same time in the 90s, when in fact there were a lot of mergers and acquisitions taking place of domestic seed companies by foreign multinational seed companies. So it was argued that intellectual property rights could lead to domination of the domestic seed industry by multinationals, and concentration in the IPR ownership would also lead to concentration in market shares. And then it was argued that the intellectual property rights regime would lead to the displacement of the public research system. So till that time, the public sector had played a dominant role in plant breeding. It was argued that the public research system would be displaced. And then it was argued that this intellectual property rights regime would lead to genetic diversity on farmers' fields being eroded. This is actually not really related only to intellectual property rights. This is really related to the argument that if you have large areas covered by a single variety, the monocultures argument, then over time, the genetic diversity in farmers' fields would get eroded. So these were the kind of concerns that were expressed, and this is what led to a lot of the farmers' agitations, and then there was a lot of debate in Parliament. A parliamentary select committee was set up to look into this legislation, and eventually a legislation was passed in 2001, but it was not just called the plant variety protection legislation. It was called the Plant Variety Protection Legislation and Farmers' Rights Act. So let us see, and also to note that there were also concerns about conservation and sustainable use of biodiversity. So we'll look at this point in a little more detail when we look at farmers' rights issues. But the argument was that breeders should share the benefits they get from intellectual property rights with farming communities that have conserved and developed agrobiodiversity. Because breeders get all their basic parental material only from the farmers. So if breeders get benefits from intellectual property rights, farmers should also get a share in those benefits. But if you give intellectual property rights only to breeders, then farmers don't get any benefits. The international dimension was that it was argued that the exchange of plant genetic resources for innovation would be restricted if intellectual property rights regimes were introduced in developing countries. So the Convention on Biological Diversity highlighted this principle of sovereign rights over biological resources, and access and benefit sharing provisions were introduced so that if a country, transfers its biological resources, then it should get certain benefits in return. The argument was that the application of IPRs on final products would restrict international exchange of plant genetic resources. So let us see how the Indian legislation responded to all these concerns. Now, the Indian legislation is a classic example of policy trying to balance different stakeholder interests. So it attempts at balancing incentives for breeders with protecting farmers. But one thing to note is that when it comes to the criteria for protection, it retains the DUS criteria. It used to be argued that, farmers' varieties, if they are to be protected, will not be, will not be distinct, uniform, or stable. But the legislation still retained the DUS criteria, because without the DUS criteria, it is almost impossible to identify an innovation. The legislation also provided that farm-saved seeds of protected varieties can be exchanged and even sold. So because of the concerns about farmers, that there would be restrictions on the use of farm-saved seed, this was made very explicit, that farm-saved seed of protected varieties can be exchanged and even sold. But while this addresses the farmers' concerns, what this also means is that the appropriability of returns for breeders is significantly restricted. Then the other people who jumped into the fray were the public sector. Now, the public sector argued that they had made a huge contribution in terms of development of new varieties. And their fear was that these varieties would simply be taken over by the private sector, who would use it to develop new varieties and then, get them subjected to intellectual property rights. So that way, there would be no recognition of the contribution of the public sector. So the Indian legislation introduced what is called the extant variety protection. See, normally intellectual property rights legislation provides protection only for new innovations. But this is a peculiar feature of the Indian legislation, which allows protection even for varieties which have been developed previously. So that is called extant variety protection. And this was mainly meant for protecting public sector interests. And the public sector was also interested that their varieties should not be, tweaked to a small extent and then claimed by the private sector. So the Indian legislation actually introduces also the essential derivation clause, which was actually a feature of the UPOV 1991 legislation, the convention. Then there are a separate set of provisions for protecting farmers' rights. And one of the interesting issues is that there was a lot of confounding with quality control provisions. So there was a fear that breeders would protect new varieties and they would be offered to farmers at high prices, but then the varieties would not perform. And therefore, farmers need to be protected against undue claims of performance which are made by breeders. So the breeders, there are provisions for penalizing breeders if their varieties do not perform. Now, this is a somewhat a peculiar provision, because normally intellectual property rights legislation, which is meant to provide incentives for innovators, does not seek to control quality. So I remember Professor Swaminathan once remarked that perhaps the Indian legislation is the only legislation where a breeder can possibly be penalized or sent to jail for an innovation. But that was because there were a lot of quality control issues that were confounded. And it used to be said that, Thomas Edison, who invented the electric bulb and got a patent for the electric bulb, would not really have sought a patent if he was to be penalized every time, a bulb fused, actually. So, but these provisions are there because there has been a lot of confounding with quality control provisions. Now, let us look at the case for farmers' rights, because the Indian legislation has got a fairly substantial section for farmers' rights, and it is considered to be quite a unique legislation in that it is perhaps one of the few legislations in the world which has got explicit provisions for the protection of farmers' rights. Now, what is the case for farmers' rights? The first argument is the equity argument. Now, breeders are able to produce new varieties only because they have access to the agrobiodiversity that has been conserved by farmers over generations. So, if breeders are to be rewarded for their new varieties, then farmers should also be rewarded for their conservation efforts in conserving agricultural biodiversity, which is what makes the breeders' innovations possible. So that is the equity argument. The conservation argument is that farmers have conserved agricultural biodiversity as a process of their agricultural practice for generations, but they get no rewards for the conservation that they have done. So the argument is, if you do not reward farmers for the conservation of agricultural biodiversity, then over a period of time, that agricultural biodiversity will be lost. So these are the arguments for farmers' rights. Let us look at how the Indian legislation tried to deal with operationalizing farmers' rights. So the question is, how do you reward farmers for the contribution over generations to the development of new varieties? Now, the problem in operationalizing farmers' rights is that these innovations are already in the public domain. Their reproductive material is already widely available in farming communities. These varieties may not meet the DUS or novelty criteria, and very precise identification of farmers or communities that developed a particular variety is perhaps impossible. So, over generations, planting material has been exchanged by so many different communities. Varieties have traveled from one country to one part of the country to another part of the country. They have been exchanged over generation by farmers. So in that context, is it really possible for you to say that Mr. X, farmer Mr. X, or say a particular farming community has actually developed this variety? So that poses an operational challenge. The approach which was taken in the Indian legislation was, they tried to create a counterpart intellectual property right for farmers' varieties. So what they said was that just like breeders' varieties can be protected, farmers' varieties can also be protected, but with some relaxation of the DUS and novelty criteria. So as we noted earlier, farmers' varieties, which are traditional varieties used in farmers' fields, may not conform to the distinctness, uniformity, and stability criteria. They are not new because they have been used for a long period of time. So you cannot protect farmers' varieties unless you relax these DUS and novelty criteria. The second provision which was made was that breeders who obtain plant variety protection for new varieties, based on, the material they have derived from existing farmers, they should contribute a portion of their revenue from the protected variety to a conservation fund. It was called a gene fund. So the idea was that if the breeders are going to get some revenues through protection, they must give a part of that as a contribution to a conservation fund. And this conservation fund would then facilitate undertaking different agrobiodiversity conservation activities. So what have been the kind of challenges in operationalizing farmers' rights? The main challenge has been the lack of authentic documentation of prevalent agrobiodiversity. That is, so how do you identify a particular variety as a farmer's variety? And how do you identify which particular community, farming community or farmer has actually developed or preserved that variety? So it is extremely difficult to attribute specific varieties to farmers or individual farmers or farming communities. The other issue is that even if you overcome these identification and attribution problems, and even if you grant, say, a plant variety protection certificate for a farmer's variety, how does that generate any revenue for the farmer? In the case of a breeder, the breeder is able to generate revenues because the breeder has monopoly over the reproductive material of that variety. But in the case of the farmer's variety, that material is already in the public domain. The variety is already widely available. The seeds are widely available. So in that case, even if a farmer gets a protection for a traditional variety, how do you generate any revenue streams? The other issue is that most modern varieties have got extraordinarily complex pedigrees. So if you look at some of the Green Revolution varieties which were developed by CIMMYT and ICAR, and if you go back, trace the pedigrees of those varieties, you will find that it contains parental material from a large number of countries, 10 or 15 countries. The dwarfing gene, for example, the Norin gene, came from Japan, and that in turn is supposed to have come from Turkey. So how far back will you go in tracing the contribution of different farming communities or different countries to these varieties? So this again poses an operational challenge. Now, benefit sharing provisions also require an anticipatory assessment of the commercial success of a variety at the time of grant of protection. That is, the breeder has to share the revenues with the gene fund, but this has to be done at the time of granting protection. But at the time of granting protection, the breeder has no way of knowing whether the variety is going to be commercially successful or not. And a lot of empirical studies have shown that a vast majority of IPRs, whether they are patents or plant variety protection certificates, generate very small returns from IPRs. So that has been another issue. So how do you expect the breeder to share the benefits from the variety with the gene fund or the conservation fund when it is not really possible to know whether the variety is going to be successful or not? So these have been a set of operational challenges, and which have sort of underpinned the implementation of plant variety rights in India. In terms of the implementation of the PVP legislation, we have a separate PVP authority. It is called the Plant Variety Protection and Farmers' Rights Authority. In many developing countries, availability of infrastructure for DUS testing is an issue. But in India, given the large national agricultural research system that has been built up, that is not really an issue, because the ICAR and institutes already had huge infrastructure for testing of varieties. One issue is whether these testing of varieties are really at an arm's length from the public sector. Because remember, the public sector is also an applicant for plant variety protection. Now, if you look at the data which is there on the website of the Plant Variety Protection Authority, you will find that to date, about 4,000 and odd plant variety protection certificates have been issued. And in fact, you can get a complete list of those plant varieties from the protected plant varieties from the PVP Authority website. But one interesting feature of the data is that most registrations are extant variety registrations from the public sector. So there is very limited participation by the private sector for new variety registrations. So what you find are public sector varieties registered using the extant variety provisions, and you have a fair sprinkling of farmers' varieties which have been initiated by NGOs or by the National Bureau of Plant Genetic Resources. But private sector participation has been rather limited. So when it comes to the assessment of impact, what can we say? One surprising feature is that although the legislation has been in place for about 20 years, there is very little research on assessment of impacts. I have really, I've not really come across any empirical studies which have tried to assess the impact of the legislation. It has been in place for almost 20 years now. So if you were to assess the impact, you could ask the question, has it provided incentives for innovation in the private sector? And largely, the answer appears to be no. Because the private sector has not really made a lot of use. They have not really rushed to file protection applications for their new varieties. The impact on agricultural R&D and the transfer of new plant varieties have come into the country from abroad, and they have continued to come into the country from abroad. But plant variety protection legislation does not appear to have played a major role in those transfers. It is really the seed policy provisions which have, and the FDI, which is in the seed industry, which appears to have been responsible for the transfer of new plant varieties. Now, protection of farmers' rights, it has, you find that there are a large number of farmers' varieties which have been granted protection. But the question is, are farmers able to derive any monetary benefits or revenue streams from this protection? And the answer to that appears to be that it perhaps serves only as a recognition of farmers' contribution, but does not really provide any revenue streams. On the other hand, you find that the plant variety protection registrations have served as a kind of a giant registry for public sector innovations. So almost all of the ICAR varieties which are currently still being used have been brought under the purview of plant. But when you have extant variety protection, what you have to really think of is that, does it really generate any revenue, even for the public sector? And I have not really been able to see how registration of varieties which are already in the public domain, whose reproductive material is already widely available in the country, simply by giving it a registration, you do not provide any revenue streams. Has it displaced the public research system? No, it has not displaced the public research system, because it continues to be fairly dominant in the production of most agricultural crops. The public sector is still dominant in, say, development of new varieties of wheat and rice. There are areas where the private sector has made a lot of inroads, say, for example, in vegetable crops, for example. But in the major agricultural crops, the private sector still remains dominant. So, so what are our reflections? Now, what it appears to me is that the Indian legislation has managed to balance, or at least it has attempted to balance, a number of competing interests. It has tried to balance the interests of the breeders or the private sector. It has tried to protect the interests of the public sector, and it has also tried to protect the interests of farmers. So it has been quite a remarkable balancing act. But when it comes to the fundamental question of, has it provided incentives for innovation, that is a much more difficult question to answer. Because does the private sector really see IPRs as an important device for protection? And the answer appears to be no. That is because the private sector appears to rely on alternative avenues for protection. One alternative avenue for protection is the development of hybrid varieties, which have got inbuilt protection. So the private sector has been mostly focusing on hybrids. The other issue appears to be that the private sector sees this legislation as granting relatively weak intellectual property protection. So in order to protect their innovations, the private sector appears to be interested more in control over the marketing and supply chain, rather than in using intellectual property rights protection. So from that point of view, it has not really served perhaps as a very strong incentive for private sector innovation. But then it has, in a sense, it seems to have sort of satisfied different stakeholders. And so today there is no real, plant variety protection doesn't really figure very much in the policy discourse, because we have at least, complied with the TRIPS provisions. We have a legislation in place. Farmers' rights have been explicitly recognized. The private sector has an avenue for protection if it wants to use it. So in a sense, it seems to have quietened down all the stakeholders. But the question of, does it really provide incentives for innovation? I think that is a question which calls for a significant amount of research. So thank you.